Good morning. The hearing board is in session. Today is Tuesday, January 31st, 2017. We're meeting in the hearing room at SCAQMD headquarters in Diamond Bar, and the time is 9:22 a.m. The board apologizes for the late start. Some things cannot be avoided. Today we have one matter to consider, and that's the SCAQMD versus Los Angeles County Probation Department, Camp Kilpatrick Treatment Plant, Central Juvenile Hall, and Dorothy Kirby Center, case 6025-2. Who is representing the executive officer this morning?
Nancy S. Feldman for the executive officer.
And representing the respondent?
Carrie Clark, County Counsel for Oh, sorry.
Mr. Chairman.
Carrie Clark.
Carrie Clark.
Okay.
Sorry.
Okay, those who will be testifying this morning, please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you.
Mr.
Senator?
Chairman, it may be a rule change necessary. I don't understand. It may be and it may not be. It states here that for modification, you need 21 days notice prior to the hearing. And this notice was posted January 17th to 2017. What do we have to do in order to justify hearing it today?
What are you looking at?
It says here 21 days, and the notice was issued on the 17th.
It's 10 days posted notice, actually, but yes, the petition is required 21 days prior, and the petition was filed on January 12th. So I had a similar question as to why it was not filed 21 days prior. And obviously, the notice was sufficient.
The petition is available. Well, the notice for petition was not noted until January 17th.
10 days posted notice is all that is required for a modification of an order for abatement. So the notice itself is actually sufficient. So we do have jurisdiction to hear the case today, but I will have questions for why the petition was so untimely.
Okay. As long as you make your point, make the record, that's all.
Thank you very much, Senator. Okay. Ms. Feldman.
It's actually respondent's petition, so they should open first.
You're right. Ms. Clark.
Your Honor, the respondent is requesting to modify the existing order for abatement, and I believe the original findings and decision are dated June 29, 2016. We're here today asking to request to modify that order, essentially seeking an extension on 2 of the completion dates for 2 of the subject facilities.
Ms. Feldman.
Yes, thank you, Mr. Chairman, and good morning, members of the board. The district is not opposed to the modification of the petition, of the order, I should say, and it's for purely pragmatic reasons. The engines are located at juvenile detention facilities. They are emergency backup engines. I would not want to put respondent or anyone in the position of not being able to operate the engines in the event of an emergency. And so it is with some reluctance and reticence, but nonetheless an understanding that the prior stipulated order for abatement warrants modification to give the county more time. As I'm sure will be revealed to you during the course of testimony, this is just kind of a sad situation. It just is, where the county kind of dropped the ball on keeping their eyes on the order as it was issued by the hearing board. The deadlines for the installation of the engines that are at issue in this case were September 30th and December 31st, respectively, at each of the facilities. They should have, by all rights, petitioned for a modification well before the September deadline. They missed it. They didn't petition in time for the December 31st deadline. They missed it. And they were here only when they were because they realized the order itself was going to expire. The hearing board's jurisdiction runs out today. And that's what brings us here today. Under different circumstances, I would oppose, and I would say, well, you just can't operate this equipment. But given the circumstances, I think it is necessary and appropriate that we grant the relief and that the district just takes whatever enforcement action is necessary outside the bounds of the order for abatement, because they did violate the prior order, in the hopes of deterring any future conduct like this.
Before we go further, Ms. Feldman, there was a prior order, 6025-1. Is this related? Is it the same equipment?
This should have the same case number.
No, this is
As
6025-2.
This is dash 2.
But there was a
Yes.
prior order.
There was a
with-
prior order that you should have,
We have it.
yes.
The question was, is it the same equipment?
Yes, it's the same equipment that's in use at the facilities now that was in use then. 6025 dash, it's a dash 2, isn't it, Rosalind?
Today's is -2, correct. I'm asking, that there was a prior order for abatement. Not in this case. Okay. 2015. Okay, all right.
Yeah,
thank you.
there's an order, yeah, 602, no, I don't know about the 6025-1 case. Those were different facilities. Also, Los Angeles County Probation Department. There were multiple juvenile detention facilities that were all in the same situation. They all had standby emergency generators that were old and needed to be replaced. And so we put them in under orders for abatement, but we divided them into 2 groups to make those that were most factually similar in one group and then the other. And this is the dash 2 group. I apologize for my confusion.
Thank you. Ms. Clark, you may proceed with your witness.
Your Honor, I'm sorry, I'm used to being in court.
Chairman is good enough.
Chairman, I would like to call Mike Holman as my first witness.
Hi, I'm Mike. I work for ISD. I'm in charge of,
Excuse me. State your name, spell it.
Oh, Mike Homan, Homan.
And you took the oath when I administered it a while ago?
Did.
Thank you. You may proceed.
Mr. Holman, where do you work?
I work for ISD, Internal Services for LA County.
And what is your title?
Building Crafts Superintendent is the title. Crafts Superintendent?
So do you work for probation?
Yes, I'm assigned.
Oh, yeah. Okay. Do you work for probation?
Yes, I'm assigned to probation to, work on all their projects.
Are you employed by probation?
No.
And as part of your employment with ISD, are you tasked with working on the issues relative to these 2 engines in question?
Yes.
What specifically is your responsibility in that venue?
We have another section that does the direct involvement. I just help any coordination and try to stay abreast of all their projects as we can.
So does ISD do the actual work on these installations?
No, these were all jock contracted out.
Meaning a subcontractor?
Subcontractor, yes.
And what is your role relative to the subcontractor?
I have really no dealing with the subcontractors. I just know that that they had hired them. I don't even know who the companies were. It's all done through the contractor program, so I don't deal with them at all.
Drawing your attention to first the Camp Kilpatrick generator, can you go through some of the delays that were experienced relative to this installation?
Yes, the generator was due to start replacement in June of this year. We filed for the permits. We put a temporary generator on site so it would cover the camps. As we filed for the permits, it took a little while to get all the permits processed, and then as we got the permit to the AQMD permit for that generator, we still needed a building permit from Public Works. They wouldn't issue us a building permit until we got the registration for the other existing generator that's on site. And so as we went through that process, that generator turned out, as we turned in the paperwork for the permit, and they came back and says, it's not, we can't permit it because it doesn't have a variance for the diesel particulate filter. So he said, wow, now we're kind of big trouble. So did a bunch of research, found out that that particulate filter was verified when it was built and installed. That variance was essentially switched over to Caterpillar when they bought the company that made that filter, and the variance transferred with it. And so then Caterpillar decided not to construct those filters anymore, so the variance kind of like died. So when they did the research for the permit, it showed there was no variance for the filter, and so we had to communicate with them that the filter was still verified. It's just that they quit manufacturing them. So they saw that, yes, that all the other filters that had been manufactured would still be variants, even though that they don't manufacture them anymore. And then we still had to get a approval for notifying all the students that were, at the school. And as it turns out, they had closed the camp, and then the other one's under construction, so there was no students to notify, so they waived that thing. And this kind of went on for, like a few months. It was.
Okay, if I can interrupt you, just to back up. So if I understand what you're saying, there were permits relative to AQMD that were
Yes.
required,
Yes.
and then there was a building permit that caused some delay.
Yeah, we couldn't get the building permit for the new generator until all the registration process was done.
And who's the entity that you obtained the building permit from?
I think it was Public Works.
So just to backtrack, there was an original petition in order for abatement back in June of 2016, and it had some deadlines, if you will, set up in that order. Were you involved in the process of choosing those deadlines?
No, it was, I don't know, how they came about. I just knew that they were very ambitious, but we had a lot of projects to try to finish by the deadline, so they picked those, but they were too ambitious, as it turned out, with the whole process.
Okay. Once the building permit was obtained, were there any other delays after that?
Well, I guess the delay would be just, getting all the people on board to, start working, and they actually, started the work this month.
Okay. Did you have any communication with the subcontractor to know that the deadlines were not going to be met?
No.
So is it fair to say that the subcontractor didn't inform you?
Yes,
And then is it fair to say that if you didn't know that, you in turn didn't inform probation?
yes.
Relative to Camp Kilpatrick, you just indicated that the installation has commenced, and the last information I think that was presented to the board was that it was scheduled to commence on January 12th, and there was some rain that delayed that. So has it started?
It started on the 24th, Tuesday.
And what is the expected time frame to complete that installation?
Our timeframe is 8 weeks, and hopefully we don't have any more rain because of the location's kind of down a muddy hill, so it gets a challenge.
So is the March 31st requested time frame to complete that installation, is that an ambitious request, or do you expect that it will be completed?
I think we can make that. That is not I don't think that will be a hard issue at all.
Now, turning your focus to Dorothy Kirby, which was also not completed by the expected deadline or the proposed deadline, can you speak to some of the delays that were experienced as relative to that?
Well, some of the ones was getting the funding. That took a little longer than we would like, but the process of getting the contractor and the vendor and all the submittals and resubmittals, and then getting them on board to start and finally getting the permits, that took a lot longer than anyone anticipated.
And is the same true with regard to communication from the subcontractor? You weren't made aware of any of those missed deadlines?
Yes, I'm not involved with those guys.
And what's the current status of the Dorothy Kirby installation?
Dorothy Kirby is waiting for generator to be, supplied. It's on order. It's lead times maybe 4 or 5 weeks, and I think all the permits are in place. And as soon as we get the generator, I think that they got the vendors, and so they can start the process.
Okay, so if I understand you, the generator is in the manufacturing phase?
Yes.
And the contractor has been selected?
I'm pretty sure that I couldn't say, I don't know if he has, but I'm pretty sure that they've gone through the whole process of the pay and the, support.
Are there any outstanding permits that need to be acquired for that facility?
I don't know if there are.
Did you ask the subcontractor?
I asked our contractor that, he said we have all our permits, but I haven't seen any of the numbers.
So you've been informed by the subcontractor that the permits have been received, you just haven't verified the information?
Yes.
What's the expected completion date for Dorothy Kirby?
I think that May 31st deadline is going to be as close as we get. The May 31st deadline is our deadline for that one, and that's what we're going to aim to accomplish.
Okay. Is there anything else you wish to add?
No, I mean, part of the delay for that Kirby one was the same contractor that's doing Central Juvenile Hall was also to start the Kirby job, so they were split between the two locations, and we need to finish Central and then move on. That's it.
I'm concluded with this witness. I don't know.
Ms. Feldman?
Yes, thank you, Mr. Chairman. I'm a little confused about what your role is. Do you oversee the project?
No, I don't oversee this project. There's too many you know, I mean, we have a project manager that oversees the project, and he's a contracted, project manager for ISD. He's not an employee.
So the project manager is a contractor, and then there's a subcontractor,
Yes,
okay, who does the actual work?
the subcontractor would be doing the work, yes.
Right. So when you say that the subcontractor didn't inform you that they were going to miss deadlines, would you expect the subcontractor to inform you?
No, I mean, well, on the subcontractor, when you say that, I'm thinking of the guy that's doing the construction work, the project manager. We would expect that.
You would expect the project manager to tell
Yes,
you?
Yes.
And the project manager did not tell you?
Well, I think we knew that we weren't going to make some of these deadlines with the delays with the process, with the permits and stuff, because that was just not going to be possible.
Right. When did you first become aware that there was a stipulated order for abatement that governed this process?
Maybe June.
So that's pretty much when it was issued. Did anybody explain the significance of the order for abatement, that these deadlines are real?
Well, I knew we had them. I didn't know that they were to be, you know, to tell anyone that they weren't going to be
That they
made.
had force of law?
Right. I mean, I know this has been going on for quite a while, this whole procedure with all the different generators and filters that were replaced. But I didn't, you know, they picked the date, and I just said, well, okay, that's what you're going to pick. I didn't know, no one had mentioned that you got to notify someone that you're not going to make it.
Okay. For the Kilpatrick facility, do you know when you first got the AQMD permit?
AQMD permit for the
Kilpatrick.
the replacement generator.
If that's what was happening at Kilpatrick, it was a
Well,
replacement,
there's
right?
two generators that are in
Oh,
play
okay.
there. The replacement was 9/19.
That's when you got the permit from the AQMD, was September 19th?
Yes, I believe so.
Do you know when the application was submitted?
Permit of. 6/22.
Okay. And there was another generator at Kilpatrick? Was that to be equipped with that's the one you were talking about, the diesel particulate filter?
Yes.
Okay. When you were talking about the diesel particulate filter, you said that it needed a variance? A variance from what? And issued by who?
Their resources board. There's if you check on there's executive letters that say that they have particulate filters that they give variance for per different engines. And they give you a list of verified filters that you can use.
So these are certified pieces of equipment that you could put on?
Yes.
Yeah, I'm just clarifying that because, you know, this hearing board issues variances that allow you to do something that's outside the rules and regulations. So you use a term like variance and all their ears are going to go up and say, we didn't hear a variance about a diesel particulate filter. But this is something totally different.
Well, that's the Air Resources Board is there.
Okay, so that's from CARB and it tells you what diesel particulate filters you can use.
Yes.
Is that right? Okay. Were you working directly with anyone at probation?
Yes, I work with them a lot.
Okay, so for this particular undertaking at Kilpatrick and Kirby, with whom were you working at probation?
It was Shanad Morgan. We have meetings with him.
Okay, and at what point was Mr. Morgan made aware that the deadlines were not going to be met?
Well, I'm sure he knew because we have meetings monthly, so I think it came up when at the September we knew we weren't going to make them. So he would have been at that meeting.
And was there, so there was a meeting, was there any discussion at the meeting about what do we do? Do we go back to the hearing board? Do we call the lawyer? What do we do?
There was no discussion. It was just, move forward with, try to complete it as quick as possible, because that's the only.
Okay. You said that 8 weeks was good for Kilpatrick. You sort of just casually tossed in there, if we don't get any more rain.
Well,
I think we're going to get more rain within the next 8 weeks. Is 8 weeks good?
Well, I mean, 8 weeks is still inside of our deadline, and, but that, I mean, the location is not accessible if it gets overly muddy. It's just the bottom of a hill out in Malibu, and we've been down there, and it's been a little dicey. I mean, I'm going to say we're going to get it done, and that's our plan, and I'm not going to wait around to not do it. So,
Are there residents there, students there now?
no,
No, not at all.
not at all.
Who's there?
Construction crew building Camp Kilpatrick.
Are students scheduled to return?
At some point, April, May, maybe.
Okay, so in the near term,
Yes.
okay.
That generator that's in question is out of commission. We took it offline and installed a portable.
Okay, is that a PERP registered
Yes.
engine?
It's one of
Okay.
our portable generators we take to sites.
Okay, that's good. On Dorothy Kirby then, do you know when you submitted the application for the AQMD permit for an engine at Kirby?
That would be December 13th.
Just this past December?
That's what they told me, yeah.
Wow, okay. I have no further questions.
Mr. Holman, what will you do if this order for abatement is not extended?
We're still going to carry on and finish the projects. I mean, that's what we have to finish, all of them. If we don't extend them, I'm not sure what our options would be.
Suppose you need to use the emergency equipment.
Well, if the power goes out, it's going to come on. They won't have any. If they don't come on, then there will be no power.
Do you have any other options?
Not at this time.
You were here on June 29th of last year.
No, sir.
Pardon? It was on consent. Okay. Okay, I do have a declaration. I have no other questions. Ms. Prusek.
This is very concerning. Obviously, an order was issued by this board, and that order was utterly ignored pretty much by the Department of Probation. And it doesn't seem, I think the only question now, I think as Ms. Feldman framed it, I think it's very important that this continue because these need to be replaced. These are engines which are emitting unacceptable levels of particulate matter too close to children. And as a result, they need to be replaced. But what I think I'm grappling with is how do we know that if we extend the order, that it will be followed this time. So the first thing I'm going to ask is, I'm looking right now at what was exhibit number 2 for the original matter that was heard by this board on consent, which means that you did not show up, you weren't asked to, but you did submit, this is a declaration from you, Mr. Mr. Homan. Do you remember, do you have this? I don't know if your attorney has this. Do you
have it.
remember? Okay.
Well, I don't have that one, I'm sorry.
Let me see if I have it in the file. And if I could just interject for one moment, I know that the members have some continued questions for Mr. Holman, but I did bring Mr. Johnson. He's actually here from probation. I think he can speak to going forward from here and maybe allay some of the concerns that the members may have. I think if you heard from him, some of those concerns could be laid to rest, at least relative to going forward.
Okay. We will, and I appreciate that. But I guess the first question I had is, you testified that the schedule that the probation department was required to follow was both ambitious and not within your, not something that you actually had put forth. But I'm looking at page 3 of your declaration, paragraph 10, where it says, accordingly, probation and ISD have proposed the following compliance schedule for Camp Kilpatrick. And then again, on page 4, paragraph 12, with respect to Dorothy Kirby Treatment Center. So were those originally your, was that your schedule
That was
proposed?
not, it was not my schedule, it was ISD schedule, and that was what they put down as their schedule. And
All right, I guess what we're going to have to understand is that by the time we deliberate, and some witness, whether it's this witness or another witness, is going to have to convince this board that at least now it is understood that orders of this board are orders with the force of law that need to be complied with. The other thing that needs to be understood is that I don't care how many contractors, subcontractors, subcontractors, subs, it is not their responsibility to comply with the order, nor is it their responsibility to follow the order and to keep track of dates. That is the responsibility of the respondent, which is the Los Angeles County Probation Department. So we'll need to know that, and we'll need to know that these new dates are dates that are realistic and that can be complied with. So I don't know if you are the witness to answer those questions or if we need to introduce a new witness. But as far as I'm concerned, those are the questions I need to know about, the answers to.
Your Honor, I think, I'm sorry, member, I believe it's Mr. Johnson that would be available to answer those questions. And this is James Johnson. He's the administrative.
Wait.
Oh.
Do we have any other questions for Mr. Holman? Senator?
Mr. Holman,
yes, sir.
Did you prepare this declaration, this one prepared on your behalf?
It was prepared for me.
So, did you understand the contents of it before you signed it? Under the penalty of perjury, you signed this.
Yeah, that was our goals, to do those things.
You said you shall do them. I shall. Shall mean to accomplish, not establish as a goal, but a specified time period when that action will be taken. You understand that?
Yes,
Now, you work for the County of Los Angeles,
yes,
and the members of the Board of Supervisors come before us saying they want clean air. And they want it not just for the private sector that's violating the rules and regulations and health and safety code, but also for themselves. you gotta know that I've been with the county for 12 years,
I know.
and I know how they operate. You have Supervisor Hilla Solis been here. You have Supervisor Hahn, Supervisor Sheila Cool is on the board here. At what time, if any, are they made aware of the fact that you slipped these dates?
I don't believe they were made aware of any of those dates.
You think they will receive the fact well that it's been slipped
No.
for a long period? That's right. And the fees have not been paid? Oh my God, you got a long history here. A non-compliance, fees not paid, cease operation of the equipment, and the district has bent over backwards to accommodate County of Los Angeles Probation Department, which I'm very familiar with. So if I'm going to, for any reason, agree to the modification or the extension of time, is with the provision that the board of supervisors make a special item. They call it special. You know what a special is around there, don't you?
I wouldn't know
They
that.
call it, on their agenda, they call it special.
Right.
To be informed about the status of this hearing and what took place prior thereto. That's going to be my position, okay?
Mr. Holman, do you know the original compliance date that is in the regulation?
I don't.
Does January 1st, 2007 ring a bell?
2007? No.
Any other questions for Ms. Bird?
Mr. Holman, did I hear you say that you had requested any expedited permits from the district when you did apply?
I don't know if it was expedited. They asked for the permits and they were,
The permit applications themselves? Okay, maybe you don't know, because you don't oversee the project, so you wouldn't know. The only thing that you know is when someone told you that the permit was submitted.
Right.
Permit application,
And then
so if they
permit-
didn't tell you, okay.
we had our project manager had a consultant that was working just on the permit process. And
Okay.
so, because,
So my understanding is the project manager is contracted, right?
yes,
And you're saying that he contracted someone to work on the permit?
yes, to help.
Okay. So you have no idea whether or not the permits were expedited or not?
I know I know they have them for Kilpatrick.
The one that was submitted, for instance, in December, do you know?
I don't know on that if it's expedited.
Okay, thank you.
Ms. Burzai?
Just one last question. The Dorothy Kirby Center, did you say, are there children present now?
There are, yes.
There are. Okay, thank you.
Who prepared this affidavit for you that you signed?
In June,
Yeah, yes.
that would be Veronica, I don't remember her last name.
That was the prior attorney for the county that handled that matter,
So they,
not me.
you know, and you taking the heat, I understand that.
Well, you know,
But also, you're in charge of that department, is that not correct? And all subcontractors.
no, I'm not in charge of
Who do
that.
they report to, those subcontractors?
They report to we have another division that handles all that side.
Was that division responsible for probation department's operation and equipment?
They would be responsible for the projects associated with probation on,
Then what is your responsibility associated with the probation department and these?
I'm more associated with the day-to-day operations of their facilities, not big projects.
And when you have a failure or non-compliance, who you report to that you got a problem?
I would report it to our bosses, you know. I guess we would report to probation, but it was not, reported to, I don't think it was reported to you guys, just Shanad.
I never known the county to be so lax in being responsive to what's required by law. I would just say to you that you got to get in step. The whole county.
Spurt?
I kind of feel like I'm going in circles. The contracted project manager reports to whom?
I believe his boss is Anthony Ng.
And he is in probation or
He's
ISD?
ISD.
Oh. And you may or may not know why then you were selected to come to testify.
Well, I work closely with probation. You know, I have knowledge of this project. I wasn't really involved in conducting all the day-to-day affairs, and I guess I was the lucky soul.
You were the lucky soul, because it doesn't, you said you had knowledge of this project.
Yeah, I mean, when we have our
But-
weekly meetings, we know that they're moving forward, they're not moving forward, here's the delay.
So you are, okay. But my understanding from your testimony was that you didn't even know that the dates had slipped, so you don't, how do you say you have knowledge of this project?
Well, I know that we had these generators that need to be replaced, and I knew there was a time frame,
Okay.
and it's not sure if I knew that the September was the time frame. I just knew that it got so many delays that we were going to be past whatever it was.
Thank you.
Do you have oversight and/or coordination of projects on facilities owned and/or in use by LA County and/or its various departments and agencies?
Yes.
Thank you. Bruce?
And you will continue to be part of monthly meetings on this project?
Weekly meetings.
Weekly meetings?
Well, we have it's just part of another list of other projects, and it's in that group, yeah.
And you said earlier that you did not understand that these were enforceable dates. Do you understand now that they are enforceable dates?
Sure,
Do you
absolutely.
Do you understand now that should these dates slip in the future, that this hearing board would need immediate notice from you that they will not be met?
Yes.
Okay, thank you.
Any further questions for Mr. Holman? Any other witnesses for the respondent?
I just wanted to have Mr. Johnson speak to the current situation and what is now put in process to ensure that this doesn't fall by the wayside in the future, and that the deadlines, hopefully the extension that would be granted would be, the deadlines would be met, and if there are any issues relative to that they would be communicated and brought to the attention of the members in a timely fashion. So would it be all right to call him to answer a few questions?
Sure.
So, Mr. Johnson, what is your title new to this assignment?
Yes.
And you've now been made aware of the issues and the deadlines and the circumstances surrounding the installation of the generators, the replacement generators.
I was made aware January 5th, 2017.
What is the, what is your goal going forward from here to stay on top of this?
You know, the goal is to get this accomplished as soon as possible, regardless or not whether they were deadlines that couldn't have been met in the past. The goal is to get this done as soon as possible. Whereas before we may have had periodic meetings, we meeting probation may have had periodic meetings with ISD. That's now been elevated where I receive weekly updates with regards to completing the project. And then if I feel like those dates we're falling short of those dates, then I will clearly communicate that with our council to make sure that we're on top of it. The reason it fell was, you know, ISD is here. but it's a probation project. The reason it fell was probation was not involved as they should have been. That involvement includes follow-up with ISD to make sure they're on top of the assignments, they're on top of the due dates, and if they're falling short, to notify council accordingly. That was not done. So, you know, it's our facility. We work with ISD on our maintenance projects, but, you know, the ball falls at probation's feet on this one completely.
In your weekly meetings that you've indicated are now taking place, has that commenced?
Yes, it commenced, actually, an email was sent out Friday, January 6th for weekly updates every Thursday.
And as part of those weekly updates, who's participating in those meetings?
From my end, I have Shanad Morgan, and he's communicating with ISD to provide me weekly status updates and to also advise me if we're falling short of meeting the required deadlines for installment.
Are you also meeting with ISD and the subcontractor as well?
One of my subordinates is having those communications with ISD and the subcontractor. No, not the subcontractor, the contractor, not subcontractor.
So in the event that there is a scheduled date that is not going to be met, is it fair to assume that you would be made aware of that in a timely fashion in one of those weekly meetings?
Yes, I've given myself an internal deadline of February 15th to see where we are regarding the status, to talk to all interested parties. If I don't feel we'd be due to rain in any other variables, then I would then consult council to request a status update, to request an extension, I'm sorry.
I have no further questions for Mr. Johnson.
Ms. Feldman?
Yes, Mr. Johnson, I understand you're very new to your position, so I don't expect you to be able to accurately reconstruct history. If the district has questions as we proceed from here, who at probation should be our contact for information about this?
That would be me.
Okay. I think I'll just defer to the board with questions.
Ms. Broussard?
Do you know the status of the projects at Camp Kilpatrick Treatment Center and Dorothy Kirby Center?
Yes.
Okay. Do you know, are there any permits left outstanding that need to be obtained?
To my knowledge, no.
To your knowledge, no. Would you know?
I would take ISD's word if, you know, I'm leaning on their expertise and advice regarding that, so.
Okay, because Mr. Homan had, I thought, said that all the permits were done for Dorothy Kilby and then, Kirby, sorry, and then he said he didn't know if the permits, if they have all the permits. Okay, so do you know, Mr. Johnson, whether any permits are outstanding?
Not for Kilpatrick, no.
No, I was asking for.
Oh, for Dorothy Kirby?
For Dorothy Kirby. Do you know that?
I don't know.
Do you know if a contractor has been chosen to do the work and installation for Dorothy Kirby Center?
I believe so.
Okay, those are my questions right now.
Anyone else have questions? Senator?
Mr. Johnson, how are you?
Good, sir.
Okay, how long have you worked in the Administrative Services Department?
I had a term of about 6 years. I went to manage a juvenile hall, and I came back. So pretty much my entire probation career has been in management services. 3 years outside of that has been in institutions.
Right, and what was your position there? Assistant General Manager, General Manager? What level were you operating at?
Special Assistant Probation Director.
And who did you report to? The general manager?
Different structure in probation. I reported to a bureau chief.
And who did he report to?
A deputy chief.
Is your position today that you currently hold is higher than the bureau chief?
No.
Okay. Then my next question, these contractors, so-called subcontractors, you were high enough position. Were you working on this project when you had any other title, other job title?
No.
Do you have any knowledge about as to who selected contractors and subcontractors for this project?
No.
Assuming this position that you now have, did anyone bring you up to date or share that information with you, given the problems that it has?
Not regarding the subcontractors. We've discussed issues regarding communication and follow-up and ensuring that the proposed timeframes are achievable.
If you have your weekly meetings and it's determined that the subcontractor and even the subcontractor, who not employees of the county, are not meeting that timeline, what's going to be your role?
My role would be to advise county council that perhaps we need an extension. I understand that there are delays with the rain that causes installation of the generators and things like that. So we'll have to take a look at it, and I'll make a determination by mid-February if I feel we aren't meeting the appropriate deadlines.
To your knowledge, do you know the timeline that these subcontractors have been working for the county in this capacity?
No.
Is it something you think you'd like to find out? Whether or not they're reliable, the response time, they're meeting deadlines, and whether or not they fall down in the job. Would you want to know that?
Well, I'm going to assume that that's going to reveal itself in the completion deadlines. If we have issues with completion deadlines, then I may want to go down that road, but my concern is to try to get this project done. And if it's not done, then that may be something I need to take a look at.
That may be true, but you check their history of compliance, and you'd have an idea whether or not they're going to let you down, yes or no. Check with those subcontractors to see how they met the timeline for other projects associated with the probation department. It gives you a clue. Wouldn't you think so?
Yes.
You got your work cut out for you. Hope you can comply in a timely fashion.
We intend to, sir.
Ms. Brusek.
I think the board would want to make sure that any cleanup is done of anything remaining that stands in the way of installation of these engines. So I would think that we would likely need in the order a provision requiring any remaining necessary permits, that there be an application no later than a certain date with expedited review. Can you, maybe not off the top of your head, but can you give us a date that makes sense to make sure that that application, is it Friday or?
Well, I don't know if perhaps we could have Mr. Homan call the contractor to confirm the information that he was provided and just confirm that the information is accurate, that the permits have all been received, because that was my understanding from what he indicated to the hearing board during his portion of the testimony. I had asked for the subcontractor to be here today to answer those questions. Unfortunately, he's not here, but perhaps Mr. Homan can step outside and make a phone call, and then we may not have to add anything into that, but at least we would know.
He put down on these notes I got from him yesterday was on January 12th, 2017, that he accepted an application for Dorothy Kirby.
I'm sorry. January 12th was what?
Like, of this year.
That you received the final permit, or?
SCAQMD accepted the application for Dorothy Kirby.
The application was just made to the district in January, on January 12th?
That's what he has put down here.
For Dorothy Kirby?
I thought the testimony was December 13th.
Maybe you have the wrong date, because January 12th is the date that this extension was applied for.
Petition was filed.
The petition, perhaps that's confusing. I think it might be best, as suggested, to have this information cleared up on a break.
Take a recess, and, yeah.
Let's take a,
Let's be very clear that we need crystal clear information. Where each of these projects stands, are there any permits still yet outstanding that either have not been applied for, have not been granted, anything? Are the engines ordered on site, ready to go? Are there contractors ready to go? What's the schedule that is anticipated? These are the things we need to know today.
we'll take a recess, reconvene at 10:35.
Denise, this is a check, Denise. Check, Denise. 1, 2.
We are back on the record. Ms. Clark?
Mr. Holman spoke to the subcontractor, and I believe there's an update with information. Mr. Holman, were you able to obtain information relative to the permits for the Dorothy Kirby facility?
Yes,
And are all of the permits, have all the permits for that facility been obtained?
no,
Is that different information than what you were previously led to believe?
yes.
Okay. What's the current information you've been given?
The current information is the AQMD permit is outstanding due to the generator that was spec'd out was determined not to be able to support the filter assembly. So they had to change the generator to support the new filter assembly. So that required them to start their permit process with the new generator.
Has that permit process been started?
Yes,
And where are we in that procedure?
I think that's the one he might have talked about that he submitted, on the 12th. I don't know when he submitted the thing, unfortunately.
Is there any expectation on how long that will take to obtain?
I don't know how long that will be.
Are there any other updates that you were given that are contrary to what you've already presented to the board regarding Dorothy Kirby?
That's the only updates that I had. That I asked him when he was going to start, and he was hoping to have this all start by April, but it's not clear.
Were you given any different information relative to the contractor? Has the contractor been selected?
Yes, the contractor was selected.
And is the equipment still being manufactured?
Yes,
So the only change is that there's an outstanding AQMD permit as a result of the change?
yes.
Is the expected May 31st installation a realistic installation at this point, now knowing what you know regarding the AQMD permit?
I would say that might not be possible. I mean, it's doable. I don't know all the steps on when they'll actually start, but it could be later than that if this doesn't work out with all these new information.
Do you know how much more time would be needed from May 31st?
No,
Do you know how much time would be required to obtain the current AQMD permit?
no,
But the application has been submitted?
yes.
Nothing further?
Ms. Feldman?
Do you know if the application was submitted with the fees necessary to expedite permit processing?
I wouldn't know if the fees were submitted.
Okay, and so is it December or January that you think the application was submitted?
Well, I think the original one was submitted earlier, but then when they found out that it wasn't gonna, that permit was not gonna work because the change in the generator, then that one.
So it was probably January, is what you're saying?
I'm thinking that January one was for the new generator application.
Okay. I have no further questions.
Ms. Bird?
Just have one, and I don't know if it matters, but the equipment's being manufactured. When do you expect to receive it?
It's not, I don't have a firm date, but it's like maybe 10 weeks,
10 weeks from when?
maybe the 10th of January.
Okay.
I don't have exact dates, but
And then you said the contractor hopes to start by April. Start what?
starting the excavation and changing out the generator.
Excavation or installation?
Okay, installation.
No, those are two very different things. Does he plan to start making it ready to receive the generator by April, or does he plan to install the generator by April.
I guess he's gonna start the prep for the site. I don't know what his plan are to start, because haven't talked to him, but that's what Gil was telling me, that the expected start date would be in April.
That's not helpful. That's not helpful. Thank you.
Ms. Prusek?
Do you understand the importance of not just the final completion date of installation, but of all the interim dates in an order?
Yes.
Okay, because when we ask questions like, were expedited fees paid, and the answer we get back is, no one knows, that was a clear requirement of the order, so that we're not in a situation where we don't either know the timing or the timing is not met, and that we take care of it as an early enough time so that we can correct deficiencies before it's a year or months or whatever out from where we are. So we can see how frustrated we are. I want to ask questions, and I fear you don't know the answer. I want to ask questions. I'd like to put additional dates in any order that we would adopt. I am not in a position right now to adopt any order that says installation will be completed by a date out in May when we have no idea where it stands. I would want to have something regarding if it's possible that expedited fees now be paid and that it be expedited, that occur. And I would want to also put in a provision regarding when commencement of installation begins, not just the end. And I would like it to be within so many days of receiving the permit that is required. Would you be in a position to tell us today how many days is reasonable once the permit is received to begin installation of, or even whether we're going to have an engine to install at that point?
I would not be able to give you a date due to, not sure the delivery date of the generator.
Okay. Then I fear we'll have to have a hard talk on deliberation. Thank you.
Doctor?
This is a naive question. Who can give us this data, this information? I must say that if I were before a board of my colleagues at a hospital and I presented this information on a patient, they would be reaching in my pocket for my medical license. And you got kids that you got there. You have a real responsibility. I don't want to lecture you about this, but I think the board is very frustrated that we don't have people sitting in your chairs who can actually tell us exactly what happened in the time frame. And I must say that any communication with the contractor, the subcontractor, ought to have some documentation, email, snail mail, a record of the conversation. We've got to know this. This has been dilly-dallying on for a long time, and this history goes way back of non-compliance. So please, let's get this on the right track so we can all be successful and be happy with it. Because right now, you have 5 people here who are very upset that we're sitting here and not getting precise information.
Senator?
Mr. Holman, I feel sorry for you. You're the supervisor, and as I see it, based on the information provided thus far, the sacrificial lamb, unfortunately. Now, my question to whomever can answer, Mr. Feldman, Has the county ever paid any fees at all for any violations, to your knowledge?
Yes, they paid multiple penalties for the last order for abatement, and they were issued a notice of violation for this present violation. We can't settle it until we have more of an idea of how long the violation will persist.
Do you know what amount that was, if at all?
It was $20,000 per facility last time, so it cost the county $100,000 so far.
To the county council? The board of supervisors had to prove that $100,000, yes or no?
I don't know, I can't speak to that. I don't.
Actually, Senator, it was broken down into 5 separate settlement agreements of $20,000 each at the request of county council so that it would not have to go before the Board of Supervisors.
Deny the request in the future so the county board of supervisors will know what's going on. And the bad image is being created by non-responsiveness.
I'm sorry.
That's why we still have this problem. County council, that was not a good thing you did, to break it into 5 different payments.
I wasn't,
Not this county council. I'm sorry if I gave that impression. No, it was a prior attorney.
Is it a private attorney?
Prior attorney, previous.
I understand the concerns that the hearing board has. Trust me, I fully comprehend what the frustration is. I can only indicate that we are trying to move forward from here. Mr. Johnson is aware of these issues. We now have been made aware through Mr. Homan that some of the facts have changed even slightly from this point forward. Mr. Johnson, on behalf of probation, will go back to his team and raise this to the next level so that we get some straightforward answers with regard to this. It's not about, making Mr. Homan the sacrificial lamb. We're all here sort of falling on our swords, so to speak, and indicating the issues and the problems that have gone on. Unfortunately, it's trying to peel back all of the layers and deal with different agencies and the elements of different agencies and the lack of communication, whatever you want to call it. I don't think anybody is disputing that those things transpired at this point, but unfortunately, we only can present the information as it's given to us. But please rest assured that these situations, this situation will be taken care of from this point forward regarding the completion of these 2 remaining engines. I know that there were quite a few items that were tasked with finishing, whether or not they were permits or installations. There were a number of items, and to that end, many of them have been completed and dealt with and taken care of. These are the last 2, as far as I'm aware, relative to this situation. So it's obviously a very fluid process. We will abide by whatever deadlines you see fit to impose in the findings and order. If probation is unable to make those deadlines, we will certainly come back here much sooner with an explanation as to what the holdup may be. But please rest assured at this point in time, with Mr. Johnson sitting here and hearing the events unfold as they sort of have this morning, we're all given some different information, unfortunately. So I understand your frustration. Trust me, I think it's felt on this side of the table as well. But going forward from here, that's really all we can do at this point. And please be assured that Mr. Johnson will stay on top of it. I will remain in communication with Mr. Johnson so that should there need to be another presentation before the hearing board, we would do so.
Take notice of the fact that the previous action in the request before us today has put the county in a very embarrassing situation where not only the county but the members of the board who served there is not aware of what has transpired previously. And it was intentionally withheld from the board by breaking up the fee payments into 5 different payments because that's over and above a certain amount. It has to go before the Board of Supervisors.
Well, I can't speak to that, and understand your concern, but unfortunately, I don't know anything about that, and
I'm not saying that you should, or you can, but I'm saying this, that whatever amount we agree to, my recommendation was my vote that Board of Supervisors must receive and sign off on payment, period. They must be put on notice. They are serving the public. The worst thing that could happen to an elected official is to be embarrassed by something that the county did not do, and they're supervising this county. You do understand that, don't you?
yes, I understand.
Okay, fine.
I'm going to suggest that we bring this hearing to a close, that we decide to grant a short extension and require the respondent to come back with firm dates, with witnesses that can testify firsthand. We had a hearing in May of 2015 where there was, in this matter, in probation department. It had to do with engines that were in violation. And in that hearing, we discovered that because people had changed positions, things had fallen through the crack. Then in June of last year, we had a consent item. Mr. Holman signed a declaration. I'll read part of it. It says, this is at page 3, line 16. It says, ISD worked with probation department on that project, which has since been completed, and they were referring to the 6025-1 case. In the interim, as probation and ISD looked to address the engines that had to be replaced, parentheses, and that are the subjects of the instant action, close parentheses, both departments experienced significant personnel changes that resulted in some delay. For example, the project manager who testified at the hearing on the previous petition transferred to a new assignment, thereby requiring myself, Mr. Holman, and ISD's independent contract project manager to come up to speed on the scope of this significant project. Then I made a note to myself. And the note says, the prior project manager testified he would set up institutional mechanisms so that this does not recur. Ms. Prusak.
I just had 2 remaining questions before we close the hearing. One is for Mr. Holman. Do you know the status of the engine at Dorothy Kirby Center? You had testified earlier that it's still being built. Is that correct?
Yes.
Okay. Do you know, is there anything required on the part of either ISD or the Department of Probation for that to be completed?
And no, it's been spec'd out and it's on order and being constructed.
And do you know of any estimate of when that would be completed?
It would just be, 10 weeks is what they told me would be the lead time on delivery.
Okay, and when was 10 weeks from when?
I believe I don't have the exact date when they would have submitted that. That was, but I believe they'll be able to, have it before April. That was what they had told me.
Okay. So do you know what month approximately the 10 weeks began? Was it
January.
January? Okay. So it was just ordered.
Yeah, that is.
Okay, thank you. And I had a question. If a witness for the district will be testifying, I just was wondering if the witness that is with us today has any idea of the status of the outstanding permit application, that's all.
No, just what's in just what's in our system, which is not always entirely accurate. But given the testimony we've heard today and the likelihood that I'm hearing that we'll have a callback date, I'll make sure to have somebody from engineering at the next hearing who can attest to the district's perspective on the permits.
I just have one question, and I'm not sure which of the respondents would answer, but we're talking about a callback date. Is it possible at that callback, I know the chair has talked about having someone who knows more about it, but is it possible to put something in writing, a timeline with the status of equipment, orders, when they're due to arrive, status of permits, what excavation is to take place, if there is excavation, and installation, as when that would take place?
Yes, that's reasonable and can be provided.
Thank you.
Does the board wish to hear from any other witnesses, either from the... Doctor?
I would just like to add to my colleague's comment, after installation, testing to make sure it meets whatever standards are supposed to be met for, that the AQMD requires.
The way I understand it is the equipment is already tested, the filter's already tested and certified. I don't know if they come out and actually measure exhaust on site. I don't know if I don't know who would do that as far as AQMD or.
You're building something, you're putting it in the ground, and you're going to operate it.
Right.
You're building it, the specs are there. You want to fire up the engine to see if it meets the specs. That's what I'm talking about.
Yes.
And those specs are the specs that have been prior approved by AQMD, I presume. So you have to see if you actually meet, I wouldn't write them a check for the engine until they met the specs. I don't think you would if it was your.
Exactly. I believe they do test it. I just never been around for them.
Well, be an interesting afternoon.
Yes.
Thank you.
Board wish to hear from any other witnesses, either from respondent or district? District wish to present any witnesses?
Not at this time. Thank you, Chairman.
Is there any member of the public who wishes to testify in this matter? I see none. Ms. Clark, do you wish to make a closing statement?
Only to respectfully request that the respondent's modification for the existing order be granted. I don't have any issue with the board's suggestions about adding in any additional dates, compliance dates, or submitting any further information to this board. Obviously, the board can see the layers of issues and problems that have led us to this point today. The only thing I can indicate going forward from here, again, is that probation, Mr. Johnson, will ensure that these deadlines are met and that the installations are completed in a timely fashion, and would just ask that the court grant the requested relief.
Ms. Feldman?
The district has no objection to granting an extension of the existing stipulated order for abatement deadlines. I would say until the end of February, at which time we should come back with a more robust order that has better defined increments of progress. From the testimony that I've heard today, I don't think anything much is going to happen between now and the end of February, which would allow us to meet and confer and get the information that this board obviously feels is necessary to put into a new order for abatement. We would be looking to respondent to work with the contractors to determine exactly what steps need to be accomplished between now and final compliance at each facility, and what deadlines would be appropriate for those increments.
Why do you believe 4 weeks is necessary for something that should have been to prepare the information that should have been brought today?
Because it wasn't. And from what I'm hearing from respondent, there's a tremendous amount of uncertainty as to who is responsible for what in this project. And I fear that if we have a comeback date that's too soon, there's going to be a lot of grasping at this date should work as opposed to this is the right date.
Thank you. Ms. Brusette.
I just want to clarify Ms. Fellman's position. So the position is to extend our jurisdiction, but not the final compliance
Yes.
dates. So that way,
Yes, thank you, Ms.
they
Broussard.
remain as
That's
they
right.
were.
That's
Okay.
right.
Thank you.
Well, is it possible to extend the compliance date on the Kilpatrick facility only because that one doesn't seem to be as much at issue as the Kirby one, and that installation has already commenced? I think there's maybe different issues relative to
Yeah,
both.
if they're willing to commit to March 31st as the final compliance date for Kilpatrick, I would not object to that. That way, we would only be hearing testimony about Dorothy Kirby, and the task before the board and respondent would be narrowed at a comeback.
I'm sorry. So the proposal on the table is to separate this order into two orders, one of which now becomes a final compliance date of March 31st and a jurisdictional extension to March 31st.
I don't think you really need to separate it into two. If you look at the construct of the proposed order, the facilities are already broken out. And I think if you just keep the Kilpatrick portion the way it is, and for Kirby, state that respondent is to report back to the hearing board by such and such a date to provide sufficient information to develop appropriate increments of progress. Instead of saying on or before May 31st shall complete installation.
Understood. However, your original position was to extend our jurisdiction to the end of February. So then we would be extending our jurisdiction over the entire order
Until end of March.
Senator.
I would support the recommendation if and only if the Board of Supervisors are informed of the action that you're requesting and why. Sometimes they need to know.
Other comments? Ms. Brusette.
I want to take a moment in a little bit to look at the finding and decision of the hearing board that has been proposed, because I'm not inclined to, other than the particular portions of the order that have been discussed, which is extending jurisdiction, putting in a return date on the Dorothy Kirby Center, and changing the date for required completion of installation at the Camp Kilpatrick Treatment Center. I'm not inclined to adopt, for example, the findings of the proposed stipulated order because upon looking at them, I don't agree with them in terms of delays were explained relative to obtaining permits, the selection of contractors, and the procurement of equipment, et cetera, et cetera. So my deliberation will essentially be as follows. These are children. They are essentially at what is defined as a school. Chairman, as you pointed out, these engines, at least from what I saw in the papers, should have been in compliance with the rule in 2007. The notices of violation and the inspections were had in 2014. Some of the violations go back to 2012 on the notices of violation. The original order was in place last year and required by the end of the year for these to be brought up to where they needed to be. We've heard a lot today, and I don't think we have to belabor the point that it's clear that every ball conceivable was dropped in this case, including the fact that this order has the force and effect of law. I feel that there is good cause, despite that, to, at least as an interim measure, to extend our jurisdiction and to extend the date for the Camp Kilpatrick Treatment Center to March 31st, and that being because it has already begun installation. There are no outstanding permits. It's a matter of whether the contractors can get it done with the rain schedule, and we have been assured that will occur. I don't know how confident I feel. However, I don't know how inclined we'll be to extend it further, so I hope that respondent feels confident. I also feel there's good cause to extend our jurisdiction on Dorothy Kirby Center because we need to continue to have an order in place that is requiring a forward momentum on this issue. And hopefully we've put an exclamation point on how important that forward momentum is today, and to have a callback to make sure that we do, in fact, have all the information, as Ms. Byrd has, I think, very competently and sufficiently laid out, and anything else that we're not thinking about that we need in order to have increments of progress more appropriately defined. And I agree that there are not likely to have any increments prior to the end of February, and that's probably a good date. However, I would like to add, when we get to the appropriate time, a requirement of expedited fees on any outstanding permits be paid immediately if they have not already been paid and if they're still available, it's still an available option. And with all of that, I think there would be good cause to extend in that manner.
Other thoughts? Ms. Byrd?
I have a thought, but it's not firm. They are having weekly meetings. Can we somehow, Ms. Prusak, can we somehow have some status even before our callback if there is anything that changes? If there is anything that changes. Or do you think, and I say that because you sounds like you're hesitant with waiting a month. And that's the only other way I can see not waiting a month. If anything does change, it will come up at their weekly meeting.
I think notice could be an issue if we don't have a clear cut date set out today. I'm not actually, unless anyone else is, I'm not actually hesitant about that because it sounds to me like they may not, even if they received their permit, if they paid expedited fees and the last permit was received, there's a 10-week lead time for this engine. So the next step would be to commence installation. I can't imagine that could occur by the end of February. So I'm not sure there's anything else that can be done.
Okay. I just thought I heard something different. Maybe that's not what you're saying.
Senator?
Mr. Chairman, members, we should add 5 to read that this order should be noticed to the LA County Board of Supervisors Chairman, Mark Ridley Thomas, and other members, that which you're requesting today in detail. And then you change 5 to 6.
Can you repeat what you are proposing?
This order should be noticed to the LA County Board of Supervisors Chairman, Mr. Mark Ridley Thomas, and the other copies to the other members.
Do you mean notice of the callback hearing, or a
Order.
notice of maybe an update on the status of this
The
matter?
update on the status, and why the update on the status, with an explanation as to why. Just with a full explanation. Things might get done after that.
You want to go off the record? We're off the record.
Is it possible for me to go and make regarding that last request, because that's something that I did not anticipate, that's relatively new. I'm not trying to play games or anything.
We'll take a short recess.
And I think it's important if you have, because we do need to get, it's a stipulated order, so we do need to get acceptance from both sides with regard to that addition of apprising the Board of Supervisors and also on,
Well, that's the one I want to find out about.
okay, so the other ones you'd be able to agree to, including the immediate payment of expedited fees.
Well, if I can just have a moment to speak
Yes.
with.
We're off the record.
And I also have some suggested language to accomplish.
Ms. Clark, how much total time will you need?
I'm hoping that I can reach somebody quickly. If
Because,
not,
you know,
are we off the record?
yeah, we're off the record.
Okay. You only convene until 11:30, is that the issue?
Well, we can take a lunch recess if you need more time.
Well, my only concern is with the last request. It's just something that's novel. I'm not familiar with that request. I'm trying to get a feel.
Okay.
No, it's not that.
Let's take a 15-minute recess. Reconvene at 11:35. We are back on the record.
Mr. Chairman, I did develop some language that I reviewed with council that addresses at least most, I think, of the concerns that were raised, if you'd like me to suggest it at this time.
Yes, please.
Thank you. First of all, I think that in light of the board's well-placed discomfort with the proposed order that you have in front of you and the determination to have a comeback date, we could just have the hearing board issue a minute order, which would just contain essentially the order part. So we can forego review of anything prior to that which appears on page 4. And on page 4, at Camp Kilpatrick Treatment Center, the paragraph number 1 would remain the same. And where it says at Dorothy Kirby Center, the first paragraph would read, respondent shall determine whether fees to expedite permit processing were paid with the application for a permit for the subject generator, and if not, shall immediately pay such fees to facilitate prompt issuance of the permit by the district. Next would be on or before February 15th, 2017, respondent shall submit a written report to the hearing board with copies to the district, attention Nancy Feldman and John Akers, that sets forth a precise accounting of all actions taken to comply with the stipulated order for abatement and sets forth a schedule of detailed increments of progress to be met to achieve final compliance. And then finally, respondent shall appear at a hearing to be held on February, and you'd fill in a date there, to consider further modification of the order. I did not, the senator will notice, I did not put words to your proposed condition, as I would like to leave that. I believe council wants to address that herself, and then I would leave that to you. But if the hearing board likes these proposed provisions, I wrote them down for so the clerk will have them. You don't have to start scribbling.
Ms. Clark?
I would just respectfully request that the hearing board not make the suggestions by Member Holden a part of the order. I will give my word to this hearing board that at this point, based on everything that has been heard here today, the matter will be elevated. It will definitely go through that process. And I'm giving you that information as a professional courtesy and asking that you not actually make it in order, but I am giving you my word that it will go up to that level. I'm just asking that it not be contained as part of an order.
That level meaning which level?
The suggestion that it be made apparent to the Board of Supervisors, because this will go back to the probation department. It will go up through the appropriate channels at probation. It will be made known through the appropriate individuals there, and it will in turn be made aware to everybody involved. I would just ask that, again, it just not be made part of an order, and I am giving you my word that it is going to go through that notification process, and the appropriate individuals will be made aware of this.
Did you want to comment?
Yeah, your language is not as precise as I would like to. I'd like to hear the words Board of Supervisors said, not appropriate. Appropriate channels don't bother me. You can go up the line, but it has to wind up in the lap of the Board of Supervisors in some form. But you have to say that. You're saying appropriate. I don't want it to be appropriate. I think that's inappropriate. I want the real words, because we have spent the morning here with non-information. I don't want any more.
I don't disagree, and if that's the appropriate wording that I need to actually articulate, that is the words. I'm telling you that it will also go up through the appropriate chain of command at probation. It will go back through my office, and it will be made known to the Board of Supervisors.
Thank you.
It will, Mr. Chairman. Yes, it will. in 3 or 4 years, please, I know the operation over there, become stagnated. It's better for you to inform the Board of Supervisors what's transpired over the years. It's a new board. Rather than to have them as a public officials, be blindsided. This is public information, what goes on here. The press picks it up. If they're blindsided, they're going to be one angry Board of Supervisors. You know, the county council has given his word before about breaking up the payments. I understand how they're going to operate. If you come to them and say, look, the subcontractors did A, B, C, and D, we've got stalled in meeting our performance dates and deadlines, they might understand that. But if you withhold the information and say it's going to go up the chain of command, and they get blindsided by this, that county council and everyone else is going to be in trouble.
I'm not suggesting that. I'm
But then
saying,
I said I would vote no unless that was done. They're going to say, why was there a no vote? Was that Holden? And why did Holden vote no? Because that's what I'm going to do. Unless it's considered, I'm sorry, go ahead.
Ms. Brissette?
I was just going to ask, would you accept that in the report that would be due to the board with regard to all the other information on February 15th, that an update as to whether or not the county Board of Supervisors has been apprised of the issue, be put into that report, and if it hasn't, and when we have the hearing at the end of February, at that time, consider putting it in as a requirement?
It's a likelihood, but, sorry.
The issue is a long-standing violation that's been gross, unrelenting negligence. That needs to be communicated.
Are you wanting to put that in?
I don't know.
Can we have an explanation of why it cannot be in the order?
I just am not aware if that's, again, I'm obviously new to this hearing board. I'm not familiar with the processes. I can only indicate and make representation that it will be brought to the Board of Supervisors. I'm just asking that it not be included as part of the order. If in coming back here in February, since my understanding is that there's going to be an updated hearing, I'm happy to present if in fact that has been done, and make that representation at that point in time. I'm just asking that it not be part of an actual order, but I am giving you my representation that it will be elevated to the Board of Supervisors.
I appreciate your comments. Let me ask you another question. You left the room, you made a phone call. You talked to somebody in the county council office?
Yeah.
And the county council is sitting on a hot seat right now for withholding the information based on how the fees were paid last time. I'm telling you, they are. And with the history of this project, they have a right and they have a need to know. They have a right and they have a need as public servants, elected officials, to know. The worst thing that anyone on the staff can do is have the elected official being blindsided by what they didn't know about. And all 5 of them are for clean air. They've been telling us that all the time. And they're going to be accused of being violators? You can't let that happen to them.
I'm not suggesting that.
County council, if you told you to come back and say what you're saying, then the county council withholding information from the board.
No, that's not what I'm saying. I'm saying that I will tell the board. It will go through the appropriate channels and the board will be notified. I'm just making a request that it not be part of an actual order. I can't address what
Just a minute, please. That's the county council.
We are back on the record. Just want to let the record reflect that the chairman had to leave and the vice chair is taking over the meeting. Okay, there was a question.
Who's the county council currently serving as county council? No. For the county of Los Angeles.
Mary Wickham is the county
Larry
counsel.
whom?
Wickham.
Wickham. How long has he been serving that position?
I can't answer that, I don't know.
How long have you been with the county?
Maybe a year.
Oh, okay, yes, understood. Well, in any case, no, I'm just, unless you become part of the order, I'm a no vote.
And I wanted to understand, because currently we have a stipulated order. And with a stipulated order, we would not be making a finding today, or obviously back in June, of any violations. However, if we determined that we wanted to include additional conditions which respondents do not agree to, then we could include them if we make a finding. I think a finding would be easy for this board to make. So my question is, I still don't understand if it's going to occur, why it can't be part of the order, and is it your position that you will not stipulate to it?
I was only asking that it not be made part of the order and suggesting that if, based upon my representing to this board, that it would be elevated to the Board of Supervisors, that based upon that information, would it need to actually be part of the order? If I am here representing to this hearing board, that it will be elevated to that entity, to the Board of Supervisors. I'm not trying to not inform them of anything. I understand the hearing board's concerns, and it will go to that level. I'm just asking that it not be made part of the order. I think the order, as I understand it, at least I'm asking that it just be limited to the issues concerning the installation of the engines. I am mindful of what has transpired here today, what this hearing board heard, and we can only move forward from here. And I'm making the representation to this hearing board that Mr. Johnson, who is now involved, will maintain these weekly meetings. He will stay on top of it. Everybody involved will maintain the schedule as it's set forth by this hearing board from this point forward. I can't address, again, what's transpired in the past. I can only move forward from here. So I'm only asking for some latitude with that in that fashion, and representing that nobody here at this point in time is going to drop the ball on this. This will be accomplished. It will hopefully be accomplished within the parameters that we've been given from the contractor, and if not, then we will come back here before this board and make the issues aware to the board, and let them know and apprise them of everything that's going on from this point forward. But that's really all we can do. And my commentary about elevating it within probation is to further assure the hearing board that the appropriate people at probation are following up on this, and it's not just somebody else having to fall on their sword. Ultimately, as Mr. Johnson represented, it's a probation issue, and it's for probation to continue to follow up on, which they will. So that's all I can say to the hearing board.
Sorry about that. Okay, well, I'm inclined to continue the deliberation and complete it unless there are any other questions before we close back up the record. Ms. Byrd?
I guess my issue with it is how will we know that that's been done? If we have it in the order, then at least it's an enforceable part of the order. If we don't have it in the order and I understand that you've given your word. How will we know that it's been done?
Well, I'll be the one obviously coming back here in February to answer to you, and I can make that representation to this hearing board. I will follow up on that.
I just wanted to address this briefly, given that we're all a little distracted right now, and it may help the hearing board make a decision on this. I can definitely see both sides here. I share the hearing board's frustration with how this entire matter has been handled by probation and by ISD. I think the lack of communication between the parties responsible for getting this done and complying with the order is inexcusable. However, I also understand the reticence of county council, who has been presented with really an unprecedented request by the hearing board to elevate the history and future compliance with an order for abatement to the highest possible levels in their chain of command. She was caught unawares, as were her superiors in her office, and so I think it is a reasonable request that we defer to their professionalism and their commitment to bring this to the Board of Supervisors. Because no meaningful progress towards final compliance, at least at Dorothy Kirby, is going to be made while we're waiting for the next hearing, I think it is the most sensible course of action to give them the courtesy of not putting it in the order and making it so public at this point. This is a public proceeding. This hearing can be viewed by anyone. The wishes of the senator and members of the board who share his concern and his desire to have it in the order will be able to hear it and see us say it, but it doesn't have to be part of the order itself, unless and until they still haven't done it by the comeback date, at which point you will have your opportunity to make it part of the order.
Would you agree to include mention in the laundry list of things for which you need to report? Well, first of all, do you anticipate this would occur before February 15th, going up through the chain and to?
I honestly cannot give an answer to that question. I don't know.
Well, then, are you averse to having in the laundry list of things for which you will report back on February 15th in writing prior to the hearing at the end of February? We have to set a date for that. The status of communication with the LA County Supervisor. So without an order, a mention that status would be included with the February 15th written report to this board.
Again, I'm just in somewhat an awkward position to, I mean, I don't have any issue with asking for information regarding the status of, elevating it. I don't have any issue with that.
Okay. Shall we commence deliberations? Did you have another question, Senator?
The board would only help you, Mr. Johnson. You're new in the position. They would say, get it done, timely, and who's blocking it will take the hit. That's how they operate. The worst thing that could happen for you, not you, County Council, you, sir, is that information has been withheld from them. And you want to comment?
Please, if I may. We will provide it. I think the only issue is making it part of an order. We have no problem providing that information, everything in its entirety, the history and current status. And making it part of an order, it takes a little different tone.
In what way?
It's an order. It's
Yeah, of course.
Right.
That's guaranteed it'll be done. Or it's suggested that it be done in any case.
We believe we have the mechanisms in place to not only provide the board and yourselves with current and historical information with regard to it in a memorialized fashion. In addition to that, we believe we have the players in place now to make it happen. If we can't make deadlines, to notify you in a timely manner moving forward.
Would you suggest or propose documenting and memorializing a statement to the Board of Supervisors saying, here's what the status of the events at the probation department regarding the combustion engine, or we're on target or not on target? How do you propose to do that in notifying the board?
By giving them the historical, the current status that we are, and the anticipated completion dates. And then we could also place in that board letter, you know, any deadlines that fall outside of the parameters, we will notify you of those as well. I think that's reasonable.
You're going to notify the Board of Supervisors in this, in writing?
Yes.
And they would agendize it?
I don't know what the protocol is.
That's the protocol.
I understand. I'm just suggesting that as a professional courtesy and with the representation that it will be taken to the Board of Supervisors, that it just not be made part of the order. I am telling this hearing board that it will go up to that level based upon everything that's transpired here today. That's the best that I can continue to say. It will go. I can make that representation or status it when we come back in February, but I'm just asking that it not be made part of an order.
Not to belabor the point, but I served on the Board of Supervisors, Assistant Chief Deputy, for 12 years. I'm a former elected official, and I must tell you, the worst thing can happen to an elected official to be blindsided about something they didn't know about that they should have known about. And I'm saying that promising is, I hear what you're saying, but I've heard that a lot. The only thing I can believe to be a fact is that when I say, when you suggested the order that you do it, you follow through. Nothing against you personally, because you've been there 1 year and you have a lot to learn in the course of a year, and here you are here today, being blindsided by things you didn't know about, and your predecessor writing affidavits that gentleman didn't know about. So all I'm saying to you is that the history has been withholding information and providing misleading information. No reflection on you, but that's where I'm coming from. They can vote their conscience. I'm just saying where I'm going to vote.
Yeah, I would like to echo Senator Holden's comments. The one thing that you didn't say, and he pointed it out, and I want to, for the record, put my 2 cents in. You didn't give us a timeline for that. You said it's going to go up. It can't, you know, the timeline here goes back to what, 2004? What? How long has this been going on? We've been having a problem with this.
Years.
I'm sorry, I stand corrected. The time. My point is that I don't want to get anybody fired. What I do want to do is, I don't want you, the probation people and this board get into trouble because with the Board of Supervisors, because they get blindsided. If you're not willing to say, you know, by the 15th, we're going to contact these people, then I say we just write it in and be done with it.
I'm saying by that's fine if you want the update on the 15th, because that's when the documentation would be submitted. I will indicate whether or not it in fact has happened. I can't give you a time frame as to, I can tell them today, or because there are some procedures that have to be followed with regard to that, but I can only,
May I suggest, board members, I think we are sort of at a standstill. I think we've heard from respondent what they are willing to do, what they're capable of. We've heard from Ms. Feldman what her position on it is, and I think what's left is for us to finish deliberations and determine whether or not we feel we can sufficiently cover this particular issue. And if I could begin, and then I'd love to hear from everyone else. First of all, I would just finish my deliberations from before with, I think that there's good cause for all of the provisions that Ms. Feldman had read into the record with regard to the substantive and making sure that the schedule is followed and us extending this order and requiring an update on February 15th and a comeback, and we'll have to pick that date. We'll do that once we're done with all the deliberations. I just wanted to be clear from Ms. Feldman, the minute order would not include, is this correct, the current provision with regard to the Dorothy Kirby Center, which was condition 2 with a date for installation. We would
Right.
not include that.
Omit that.
Omit that, okay. And I think it would be good at this point. Madam Clerk, did we mark this exhibit? I don't think so. So let's mark the proposed findings and decision that we received this morning with regard to the January 31st, today's date. What is the next? Exhibit for respondent. A, right? This is from respondent. So we'll mark that as Exhibit A. We also received, which I'm not sure we really need to, we'll mark it, but we also received an addendum to the proposed findings, and we'll mark that as Exhibit B. But given that we're not going to, I'm not going to propose that we adopt these findings and decision. Instead, we just take the provisions out of it. So let's just mark it. And so with that, I find that there's good cause for that. Let's talk about the issue of requiring in the order for a respondent to take this issue and elevate it to the LA County of Supervisors. I mean, I agree that we need sticks in this case because rather than carrots, because we had the original rule, which was not complied with. We had inspections. Regardless of those inspections, we had NOVs issued. Those NOVs were issued in 2014. We came back in 2016 with an order for abatement. We ordered it in June. We all heard today it was not complied with. I heard from Ms. Feldman earlier today that the district plans to increase the penalties as an incentive to make sure that this order that we would adopt today would be complied with, and that's all well and good. I also heard from Ms. Clark that she's giving her professional representation to us today that this will be elevated. Personally, well, I agree that it needs to be elevated, but I personally agree that that would be sufficient so long as Ms. Clark has agreed, that in the February 15th written report to this board, it includes an update on as to whether that happens. And that will give this board the opportunity at the end of February, if it has not occurred, to then place it in the order and ensure that it happens immediately. That's my feeling on the matter.
That's a very
Dr. Leonard.
Solomonic way of doing this. It's reasonable because if we don't hear anything, if there's nothing moving on the 15th, then we should act and put it into the language of the order. And I would buy into that. I think that's a very good idea.
And I understand the time is of the essence, but I think it was Ms. Feldman who pointed out nothing can occur between now and then, and nothing can occur between now and the end of February. And so to make it occur earlier by placing it in the order now and not accepting the representations of Ms. Clark would not have any effect anyway. Ms. Bird?
I would agree. And there was and maybe this is a discussion for another time because it probably isn't necessary at this point, but this is something that's never been done. Not that I believe that you shouldn't do things that have never been done, because we do them all the time. But I guess the point I'm getting to is we want the outcome, however that can be. And if it means that we can get information within a couple weeks, I'm willing to allow for the representation of council today that this will happen. I will not be happy if this does not happen. And there's no way that I would go any further. I would probably be not open to many other suggestions that council may come back with if this does not happen. I can say that. But I am willing to, I can find good cause to extend this. We're going to have a comeback within a month. And I'm willing to do that.
Anyone else? Senator?
If the county board of supervisors were aware of the problems associated with this project early on, years before, I guarantee it would have been resolved by now. And you withheld information to the extent where children's health, public and safety has been somewhat put in jeopardy. Then who's to blame for that? I must tell you that you won't get a unanimous vote. And by not getting a unanimous vote, maybe you'll be inclined to do what you say you're going to do. And I believe you will. You gave your word. But that's going to be a mark on this vote that I voted no. And then, therefore, I think accountability is essential in this case. The buck stops with the county board of supervisors. Pertinent information associated with the health and safety and welfare of that community should not be withheld from the county board of supervisors. They're designated by the state of California to be in charge of the health facilities, health for LA County. They're the ones who are in charge of health and safety, designated by the state and its constitution. Now, if they didn't follow through, that's a real problem. Anyway, that's my vote. It's coming.
Ms. Byrd?
I just wanted to say one thing too, and I guess this is not something that we got into much because it's a stipulated hearing, but these are backup generators, and they're not generators that are in use on a regular basis, and we're talking about maintenance and testing, basically. And for that reason, not that we had to find any fault, but that does color, I think, the whole, my whole picture of what should have happened and how it should have happened and how quickly and how far we would elevate things. And that's all I have to say.
Thank you for that. Very good point. And also, I wanted to also make along those lines the point that we are, in my motion, which I'll make in a moment, it would be to extend also the installation time for Camp Kilpatrick Treatment Center, and the children are not present. And won't be before March 31st. So good points all. So if there is no other discussion, then I'm going to make a motion. And that is in the matter of the South Coast Air Quality Management District versus LA County Probation Department, Camp Kilpatrick Treatment Plant, Dorothy Kirby Center, case number 6025-2. I move that we modify for good cause, as stated, the stipulated order for abatement as follows. From Exhibit A for the Camp Kilpatrick Treatment Center, that we adopt what is currently Condition 1 of that order with regard to completion of installation, the final date for that being moved to March 31st of this year, 2017. And just a little cleanup matter, then the second sentence, changing respondent will notify to respondent shall notify the district within 48 hours of completing installation, et cetera. I also further move that we modify the order with regard to the Dorothy Kirby Center by adopting the 3 conditions that were read into the record by Ms. Feldman with regard to the payment of expedited fees if they have not been paid, the February 15th written submission to this board, and I believe it was also to the district, and to add to that the status of alerting the LA County Board of Supervisors.
I have suggested language for that too, if you.
That would be great.
So that condition would now read, on or before February 15th, 2017, respondent shall submit a written report to the hearing board with copies to the district that sets forth a precise accounting of all actions taken to comply with the stipulated order for abatement, including a report of whether, and if so, how, the facts of this case have been reported to the LA County Board of Supervisors, and sets forth a schedule of detailed increments of progress to be met to achieve final compliance.
Thank you, that's perfect. And just so the Madam Clerk knows, I'm gonna ask Ms. Feldman, of
have
course,
it.
to give those to you at the conclusion of this hearing. And then third, the provision with regard to a return date. And I'm gonna ask the parties if February 28th, which is a Tuesday. I do have the book. There, we have nothing currently scheduled.
That's acceptable to the district.
Okay, so then we'll fill in the blank with the date, the return date as February 28th, that Tuesday. Oh,
Yeah.
Dr. Lerner.
We're going to wait 2 weeks.
The report is due February 15th.
And we're going to meet 2 weeks later. Why aren't we meeting 1 week later? Why don't we get this thing off the table and done with? Because there's nothing else to do. I mean, that other extra week that I would propose we omit is not, unless we are booked and they are booked, I think we should just act on it and just continue the momentum. I feel
I would
very
be fine with
strongly
that
about that.
if the parties tell us now that they are both available and able to come with the information we want. The danger is nothing can occur between now and the end of February, so coming earlier won't make much of a difference, but we do not want to be in the same situation that we are today where we do not have all of the relevant information. And there are so many balls in the air. The question is, will we have it by earlier than February 28th? And we can ask Ms. Clark whether or not it makes sense to come in a week earlier, or if we just keep it at February 28th.
Well, I don't disagree that what's currently in process right now or in progress is the building of the generator. So I think with respect to an update on that score, we would only be able to provide information as to the status of completion. I don't know if there can be calls made to get some sort of a timeline or an updated timeline on how long that's going to take, maybe provide some more information with regard to that. I don't know that that impacts the hearing date. We will try to present that in the information that's provided in the written statement for the 15th. It just may be that the additional 2 weeks, there may be some more information that comes in that we would have available to present. What we put in the written statement on the 15th may not change from the 15th to the following week. I'm only suggesting that as an indicator to give some more time to get updates as to the status of the generator. The rest of the...
So are you saying today that by February 21st, well, by February 15th, and then subsequently by, say, February 21st, which is a week earlier, if we were to have a hearing, that we could not have we would not have an update on the status of the generator being built?
No, I'm saying you would. I'm saying we will do what we need to do in order to provide you the information in the written format on the 15th, what you've requested. We're going to comply with that request and give you the information that we have. I don't know, to me, it doesn't really matter, the 21st, the 28th,
Okay.
if the court.
Thank you. Then what I'll do is I'm going to, based on Dr. Lerner's concerns, and I think the board's concerns, which I've been hearing expressed regarding the County Board of Supervisors and making sure all this moves forward, then if both parties are available on February 21st, we are available on February 21st, and I will instead insert that date. And that works for the respondent? Okay, so then I will amend my motion, and I will put in that date of February 21st, 2017, and we will extend our jurisdiction to March 31st, 2017. And I don't believe there are any other changes, and that completes my motion. Is there a second?
I will second it, and then I have a question. I'm looking at what was proposed, Exhibit A, and on page 5, it says the jurisdiction continues until May 31st. And I guess somewhere I missed why we're going to March.
The reason why we are not adopting this order, this proposed order, instead, we are adopting essentially two things. One, with regard to the different treatment centers that have not yet been completed.
Right.
Camp Kilpatrick Treatment Center, we received reasonable assurance today that that installation is already underway and should be completed by March 31st.
Right.
So I want to make sure that our jurisdiction extends at least until that is completed, and part of my motion is to push out the date for completion of installation to March 31st, 2017. We do not have sufficient information today to set a date by which the Dorothy Kirby Center should now be completed installation. We don't even have information to say when it should commence.
Okay,
So as a result, my motion is only willing to push out jurisdiction as long as the first treatment center can be completed, and we can hear back from the respondent both on the 15th with regard to status and then for the comeback date.
Okay, so we know that all of that work won't be done. So you're saying that that's because we will revisit that at the comeback?
That's
The
correct.
jurisdiction date.
That's
Okay.
right. So we're going to just leave in the order, it's just going to stand, the dates that stood already for
Okay.
the Dorothy Kirby Center still stand until we come back.
All right, thank you.
Is that clear to everyone?
Just want to be clear, the number 5, somehow or other, I scratched out May 31st and put December 31st. I think that was part of some conversation here earlier.
We're going to make it March 31st.
Okay.
And then at the February 21st hearing, we're going to discuss the other center, the Dorothy Kirby Center. We will discuss increments of progress and a final compliance date at that point, and we will extend our jurisdiction if it makes sense to do so at that time.
Thank you. Sounds good.
Any other discussion on the motion? Dr. Lerner, how do you vote?
In favor.
Senator, how do you vote? She seconded the motion.
No.
Thank you. The motion passes 3-1, and we will hear from you on February 15th and see you on the 21st.
Thank you.
Thank you. Any other matters, board member? So- I'm so thrown off.
The status, a timeline of what they did.
We are
with
adjourned.
Kirby. And, you know,
I'll take care of that. I'll take care of that. Put you in a bad spot. Oh, yeah. Friends like that, you don't need any.